my lord. I was just about to go to the Act itself.
Yeah.
Authorities Bundle, tab 1, page 1. Section 5, which the court has already seen, it is, we say, important to have in mind because it links with Section 130A, which I'll come to, and the mandatory obligation to issue market study notices in certain circumstances. Section 6 and 7 on the next page relate to other functions of the CMA, provision of information to the public. Section 7 of at least tangential relevance to some of the matters before this court, because it's providing for an express function of giving information or advice to ministers of the Crown, which might include, for example, we need to get on with legislation, or might include, for example, we need to remove the time limits in section 131A and B, which appears to feature in the latest legislation pending before Parliament. Section 129 is the interpretation section. I'd just like to note two aspects of it in passing.
What page is that?
Page 8.
Yeah.
The definition of action doesn't feature, as you will have noted, in the CMA's arguments before this court, but a central component of the CMA's case before the CAT was that it was entitled to act as it did as at June 2022 because it was taking action at the end of the market study process and essentially as part of the market study process in proposing an MIR. Now, as you've heard today, it's a central, and seen indeed in the skeleton, it's a central plank of the CMA's case that it has to establish clear blue water between the market study process and its proposal for an MIR to escape the time limits. So I just note that in passing. 4 definitions further down, you have change of circumstance, including any discovery that information has been supplied which is false or misleading in a material respect. Now, as you'll see in a moment, some provisions of the legislation allow earlier decisions to be revisited where there has been a material change of circumstance. The provisions we're concerned with here, and the time limits as we contend them to be here, do not contain such a get-out. So that's 129. And then moving forward, of course, as has rightly been emphasised already, the primary provisions requiring consideration really begin at section 130A at page 12 and following. So 130A 1 and 2 impose an obligation, not a question of discretion, impose an obligation on the CMA to publish a market study notice where it is proposing to carry out its functions under section 5, which we've just seen, namely the functions of information gathering and review for the purposes identified in subsection 2, which you've already been taken to. And then by section 130A3, the market study notice, when published, is required to specify the matter to which it relates, subparagraph A period during which representations may be made to the CMA in relation to the matter, subparagraph B, and the dates by which the CMA is required to comply with the requirements, and I emphasise the word requirements, imposed on it by sections 131A and 131B. Now, the market study notice in this case did all of that. The matter was the supply of mobile echo systems, and it's common ground that the matter specified in the market study notice is the same as was the subject of the proposal for an MIR and the decision that there be an MIR. The period for making representations, including specifically on whether there should be an MIR, was set to expire on the 26th of July 2021, 6 weeks later. And it was said in the market study notice, we respectfully say entirely accurately and consistently with the interpretation of the Act found by the Tribunal, that if the CMA proposed to make an MIR, it would publish such a proposal no later than the 14th of December 2021. And any action it would take, not any fresh consultations it would launch, any action it would take by the 14th of June 2022. And it's worth just emphasising, I would respectfully submit that notice and what it said. The tribunal has it in the supplementary bundle at page 37. And the specific invitation to the world at large to make any representations about whether there should be a market investigation reference is in paragraph 4. And that answers, we say in part at least, the question posed by my Lord the Chancellor. What is to happen if there are representations made later in the day with lots of people proposing that there be an MIR? Well, both Parliament through the statutory scheme and the CMA through this notice have set the window within which representations about an MIR should be made, and none were made. And then, as I say, paragraph 5.
If they don't comply with, if people who might make representations don't comply with paragraph 4 of the notice, then objections subsequently are of absolutely no use whatsoever.
The only way they could be, they're not of use to get around the time limits.
Well, what use are they?
Well, they're not.
In your case, the only thing they can do is to act within the time limits under section 131B.
Yes.
They can't issue. They can't just act under section 131 on the basis of there having been a whole raft of representations after the 26th of July 2021.
On our case, my Lord, they could only be of use if they provided a platform for the proper issue of a fresh market study notice, or if they provided a platform for a proper contention that by virtue of material changes in circumstances, the matter which was the subject of the market study notice is not the matter which is the subject of the proposed MIR.
But if just to test that, if I may, if the whole raft of representations come in after the 26th of July 2021, which could have been made earlier because they relate to this, then you would presumably say that didn't entitle the CMA to issue a fresh market study notice.
To issue a fresh market study notice, my Lord.
In relation to those representations, because they could and should have been made earlier.
If they didn't show that there was any new information which
That's
required
the point.
review, yes, my Lord. If they did show that there was new information requiring review, then a market study notice could be issued, and that's why I took the court straight away to section 5 and the interaction with section 130A.
Okay. And on the second reason you gave, by virtue of a material change of circumstances, which means that the information, do you mean is no longer in relation to?
Yes, no longer in relation to the matter specified in the market study notice.
Yeah. So, like the cat, you think there is a great deal to be attached to the words in relation to?
Yes, and in relation to the word shall, which I'll come to.
Absolutely, no. Just one day. I thought that's effectively what it was. Yeah.
Yeah.
Thank you.
And as I say, paragraph 5 sets out an entirely accurate summary of how the interpretation is to be interpreted. If the CMA is to propose to make a market investigation reference, then it will publish a notice of that proposal and begin the process of consultation under section 131A2 no later than 14th December 21. I'll come to this in more detail, but perhaps it's a convenient point just to respectfully attempt to articulate our difference with the summary my Lord Justice Green was putting this morning as to the effect of section 131A and B and the time limits. They are significantly more, we respectfully submit, than a procedural code designed to facilitate consultation. As we'll see in a moment, what they in fact do is require a positive decision, market investigation reference or not, no later than 12 months, once you are in the first of the two regimes I identified at the outset, namely a regime which has a published market study notice. Everything is aimed at that ultimate outer limit. And so, yes, it's true they relate in part to consultation, but everything about the consultation is to allow a clear and final decision at the 12-month point. So section 131 itself, before we get to the time limits, 1311 and 1314 are obviously of considerable importance. And the CMA says...
I'm so sorry, can
Yes.
I just press you a little bit on that? I understand that point. The CMA says that even if that were right, it's not specified as one of the three conditions for the triggering of 131, and you're effectively saying, even if you're right on that analysis, it has inferentially some additional limiting effect on the 1311 power, even though it's not specified there.
In 1314?
Yeah.
Yes. Yes, my lord, I am. And I'll come to that. But in a nutshell, 1314 does not purport to be exhaustive. And we know it's not exhaustive because I can identify constraints on the market investigation reference power which are not mentioned there. I'll explain that.
So it may boil down to what did Parliament intend when it used the words in relation to, which even if it goes, I understand the point you make.
Yes, my lord.
It's conditional, but it may be conditional plus. I mean, sorry, triggering
Yes,
consultation plus.
We say we get quite a lot of assistance actually, perhaps unusually, but in any event, we say we get quite a lot of assistance from the secondary materials, which I'll come to, which talk in terms of time limits being imposed upon the CMA, talk in terms of the policy imperative of limiting the period for which market participants are to be exposed to markets work, and talk in terms of the grant of, to risk using the adjective again, intrusive powers to facilitate compliance with those time limits, not simply to allow you to comply with a code which sits entirely alongside a freestanding power which you can always fall back on.
So it may boil down to, the real difference between you is whether the reference to in relation to was intended by Parliament not just to play a role in ensuring tightness within the 131A and B regime, but also as a limit on the broader 131 power. And it may be, what did Parliament intend? What is the proper construction of the Act in the light of Parliament's intent?
Yes, that is the question. And questions about public law constraints and Padfield and so on do not arise, we respectfully submit on this.
If you're wrong, you accept you didn't run a rationality challenge. If you're right, then
they fall away.
They fall away. Yeah.
So 1311, obviously important and understandably relied upon by the CMA and characterised by the CMA as the starting point because of the breadth of the power that it confers. We say, with respect, the breadth of the power to make an MIR does not help the CMA on this appeal. The key starting point of the analysis, we say, on this appeal is that a market study notice was published. And we say, on the natural reading of the legislation informed by the secondary materials, that had the clear implications for the timing of any proposal for and any decision as to an MIR of the kind I have articulated. Furthermore, we say, the breadth of the power in section 131 and the low threshold which it sets for a reference, one of reasonable suspicion only, make it absolutely clear that there really should be no difficulty in compliance with the relevant time limits, particularly against the background of the powers conferred. And that in turn, we say, shows no practical difficulty is actually presented by the interpretation of the legislation identified by the CAT and which we respectfully support. So section 1311, obviously important, obviously relevant, but it helps us, we say. Section 1314 is obviously critical, and the question that arose this morning and the question that has been posed by the CMA is to say, well, if the time limits you rely upon are intended to circumscribe the power to make a reference, why aren't they referred to there? And that's obviously a perfectly reasonable question. The answer to it is, as I say, firstly, section 1314 does not on its face purport to be exhaustive. It could have said a reference is only prevented where A and B and so forth. Perhaps more importantly, we know it is not exhaustive. And we know it is not exhaustive both because of the stance adopted by the CMA and because of the legislative scheme itself. Section 169, which we'll come to, shows that outside the context of a published market study notice, a reference cannot be made without consultation. There's no reference to section 169 and that restriction here. Secondly,
can I just make
yes.
sure you're on the same wavelength as the CMA? Because I understand 131. 1311 and 1314 address two different incidents of the power. 131 is a condition precedent for the power to arise.
Yes.
And if it arises, it's not unfettered. I think you both agree on that.
Yes.
There may be other restrictions, wildly improper purpose.
Yes.
Something quite immoral, illegal.
Yes.
1314, though, is definitive. It completely fetters the exercise of the power. The power does not arise at all. So you have two examples of 1314 when you
Yes.
cannot even, you just don't get near the power.
Yes.
1311 triggers the power, but it's not unfettered.
Yes.
So even when you're in the 1311 situation, there are still other matters which may prevent the power being exercised.
Well,
Is that fair as a categorisation of the way they structured the work?
Yeah. 169 is an example of the latter, isn't it? Yes, effectively.
You see, the question is, where do other fetters go? Do they go into the exercise of the
yes,
power?
my lord, I'm only hesitating to agree with your lordship's summary because
It's very sensible to hesitate to agree with me.
Yes.
1314, my lord, no reference shall be made.
So it's absolute, isn't it?
It's absolute, but it's not saying the power to make a reference shall not exist where. It's imposing a bar
Yes,
on the making of a reference in two identified circumstances.
yes.
And the question we say is whether or not those identified circumstances are exhaustive or not, or whether once you look at 131A and B and the words shall make a proposal within 6 months, shall make a decision within 12 months, shall make a reference within the report at 12 months, impose further create further examples of where the power shall not be exercised.
I think the difference, Mr. Williams simply says that goes into the word may in 1311.
Well, I don't know. We would respectfully submit we don't know where he gets that from.
Right.
We agree section 1311 is power, not obligation. And the question then is, what does the statute tell us about the circumstances in which the power may not be exercised? Because we know the section 1311 criteria was satisfied in this case, as at the 6-month point. The CMA said as much. So the only question then is there any statutory bar on the making of a reference later because they don't do it within the time frame anticipated?
Again, boiling it down, we ask ourselves, what did Parliament intend when it imposed an absolute fetter in the 1314? Examples when you can't exercise the power.
Yes.
But then it created a power which can swing both ways, for or against the CMA in 1311.
Well, we would say, when we look at them, we would say Parliament is intended by section 131A and B the same as it is intended by section 1314.
Right.
It's set out mandatory criteria.
And that's the essence of this case.
That's the essence of this case.
Mr. Williams accepts that what happened before may factor into the may
Yes.
in 131.
Yes.
You say it goes into the 1314.
Yeah. We say it's equivalent to 1314.
Yes.
And it is a hard-edged jurisdictional barrier to the exercise of the power.
So then the question is, why didn't Parliament put it into 1314?
And we would say it didn't need to in circumstances where, that's why it's important for me to fend off the idea that section 1314 is exhaustive.
No,
And we know it's not.
Absolutely understand. It's really a very narrow point, isn't it? And we've got to work out what Parliament intended by the structure. But I think we will be assisted, as you've indicated, by some of the extracted material.
And on that, speed of decision making matters for everyone. It's not just Apple and Google who are the subject of this.
Yeah.
It matters for the public and the consumer.
Yes.
There's an imperative in the CMA, if there's a problem, in getting on with things.
Yeah.
And we say that is served by our interpretation. I'll come back to that in more detail. For present purposes, as I say, all I'm seeking to do is say 1314 is not exhaustive.
Absolutely understood.
Yep.
So that takes us then into 131A itself, imposing particular notification and consultation requirements on the CMA where it has published a market study notice, as we would have it, where that regime is in play. It states by subsection 1 that the section applies where the CMA has published a market study notice and where one of two circumstances is present. First, where the CMA is proposing to make an MIR in relation to the matter specified, or secondly, where a representation has been made within the relevant period that there should be an MIR, but the CMA is proposing not to make one. Apple's case, accepted by the tribunal, is very simple. It's that these words apply without modification or gloss. The section applies whenever A, a market study notice has been published, and B, the CMA is proposing to make an MIR in relation to the matter specified in that notice. And as the tribunal found at paragraph 43, and as the chronology of events shows, both criteria were satisfied in this case by June 2022, when the CMA proposed an MIR and sought to commence consultation, having already published a market study notice. Now, the CMA's case on analysis requires instead that the words within 6 months of the market study notice are to be read into section 131A after the words is proposing. And that's, I think, the argument they encapsulate in 58C of their skeleton argument. And we invite the court to reject it for 3 reasons. Firstly, if Parliament had intended to use those words, it could readily have done so, and as we shall see in a moment, it does so later in the Act. Secondly, such an approach would make the time limits effectively meaningless. Now, it may be that there's not a huge difference between us in that respect, because the CMA says all the time limits do is establish some kind of code which sits alongside the section 131 power. But objectively viewed, the limits we say are rendered meaningless. They could only be breached if the CMA decided within the first 6 months of a market study that it would propose an MIR, but for some inexplicable reason, failed to publish that decision and begin consultation on it. Now, we say that's an inherently improbable scenario for Parliament to take time to legislate over. That's the second reason. Thirdly, that interpretation would have very odd results. It would mean that the time limits applied if a decision was taken, say, after 5 months and 27 days, but would leave untouched and unconstrained by any time limits a decision to propose an MIR taken after, say, 6 months and 1 day. Instead, the whole thrust of this provision and the subsequent provisions we'll come to, we say, is to show that the outer time limit, the outer period to be complied with, is the 12-month one. And a whole series of steps have to be taken prior to that to make that real and viable and properly decided upon. And they embrace a publishing of a proposal for an MIR, if that's in play, within 6 months. Consultation on that within 6 months, and a decision at the 12-month point. And as I said earlier, that is why we respectfully disagree with the summary my Lord Justice Green was putting, both in characterising these as procedural matters and in summarising the scheme in the way that I understood my lord to do, as market study, consultation, investigation, and decisions. It's not that, it's market study, and then at the 12-month point, investigation, reference, or not. And within that first 12 months, it's publication of a proposal to allow informed consultation and decision point.
It comes back to the point, you start at the end, which is decision,
Yes.
and everything's construed in that light.
Yes, and we'll see that supported in, again, in the secondary materials, because it's starting at the end that matters for the purposes of the consumer as well as for the market participants. And the whole thrust from the market participants' perspective is, what's the overall period for which I'm going to be subject to markets work? When you publish the market study notice regime, you're taking for yourself 12 months in which you can exercise these powers. If you make a market investigation reference, you've then got another 2 years after that.
The circumstances in which, just looking at the interplay between 1311 and 131A and B,
Yes.
the circumstances in which you can actually have a follow-on or a piggyback 1311 are quite limited. If in your 131A and B, the CMA comes to the conclusion there are no reasonable grounds for investigating or referring, then by definition,
That's it.
you can't trigger a 131 because
Right.
the condition isn't met.
Yes.
So it's only if during a market study the CMA comes to the conclusion, which is otherwise, or that there are reasons but they're not going to, that you'd ever get into the discretion in 131. Now, there may be circumstances where if they fail to act for any good reason and there's no change of circumstance, the court may say, well, that's an improper exercise of the power. You can't continually vex without good reason. But it's not as if they don't completely overlap. There is quite a strong overlap between the two. But there are some circumstances under 131A which are not mutually exclusive with 131.
Yes, there are things you do in a market study which aren't concerned with a market investigation reference and don't lead to one, and we see examples of that in this case. But the whole thrust of these amendments, 131A and B, was, we say, to tackle the problem that was presented by the fact that on the legislation as it stood, the CMA did not have power to exercise intrusive power. Did not have power to exercise the intrusive powers of evidence gathering, compulsory attendance, and so on, unless and until it believed that there were grounds for a market investigation reference. And what this did was to say, well, that's not necessarily serving the consumer or the wider public adequately. So we're going to confer powers on the CMA to get on with things before they reached any view at all, without any even subjective belief about anti-competitive conduct. Clothe them with these powers, but impose time limits. And then you can see, we respectfully submit, real force in the interleaving between the market study and the investigation reference of the kind that the tribunal found persuasive. So, 131A provides subsection 2 about the publication of the notice. Subsection 2 is also important.
Sorry to go back to something
Yes.
you said earlier. You made the submission that 131A subsection 1 applies to the facts of this case upon a literal interpretation.
Yes.
I don't recall off the top of my head, but I think it's implicit in the tribunal's reasoning that they accepted that. And was that actually in dispute before the tribunal? Because I'm not sure that they explicitly sort of, as it were, resolve any dispute as to the interpretation and application of 131A1.
No, Manuel, they make the finding about it, paragraph 43, where they assert section 131A clearly does apply in the case of the decision, because one, the CMA has published, this is page 72 of the core bundle, one, the CMA has published a market study notice, and two, the CMA is proposing to make a reference under section 131. What they didn't expressly address in the judgment were two alternative submissions about the correct interpretation of 131A, which I've just been showing the court. If you go back to that at page 19, it was submitted first that section 131A meant is proposing at the time the market study notice is published that there should be, or proposing to make a reference. That argument's not repeated before this court by the CMA. And it was also contended that the words within 6 months essentially should be read in, so that the proposing had to be within 6 months. Neither is expressly addressed in the reasoning of the tribunal, but for the reasons I've sought to explain, the only one that's still in play is wrong. I wanted to emphasise 131A2 to support the submission I've been making about it being the end point that matters. The CMA shall consult the relevant persons about the proposal in such manner as it considers practicable before deciding whether to make a reference. And then subsection 6, in considering what is practicable for the purposes of this section, the CMA shall in particular have regard to the restrictions imposed by the timetable for making the decision, see section 131B. And that, we say, is a strong indication that it's the 12-month point that matters, and a strong indication that in a market study notice context, it's the time limits set out by section 131B which occupy the field, as I put it. There is no suggestion that it can be open to the CMA to engage in a consultation process without regard to that outer time limit of 12 months, which is objectively what's happened in this case. Quite the contrary, we say. So then we go to section 131B, which imposes the particular time limits which we're concerned with here, and that's at page 22. 131B first, 131B1 first, and we see the opening words of that subsection identify two triggers for its application. First, the CMA must have published a market study notice. Well, it's of course common ground that's satisfied here. And secondly, this must be a case to which section 131A applies. And as to that, as we've just seen, section 131A applies where the CMA is proposing to make a reference in relation to the matter specified in the market study notice. If those two triggers are met, then two things have to happen. As the statute says, using words not present in 131A, two things have to happen within the period of 6 months, beginning with the market study notice. First, the CMA shall, and it's shall not may, publish notice of its proposal to make a reference. That's the effect of section 131B1A. The notice of proposal is the notice under section 131A2A. So notice of proposal, it should be an MIR. And secondly, the CMA shall, within the same period, begin the process of consultation on that proposal. And it follows, we say, as the tribunal rightly held at paragraphs 43 and 44, that if the CMA is to make a proposal for an MIR in relation to a matter specified in a published market study notice, it has to do so within 6 months of publication of that notice. It has to do so, we say, because that is what serves the statutory purposes of expedition, certainty, and balance. It has to do so because that is what allows the CMA to comply with the 6-month time limit for publication. And it has to do so because that is what allows for practicable and fair consultation as defined in the legislation in advance of the overall time limit. And it merits emphasis, we say, here, that the 6-month point is an important fork in the road. At that point, the CMA has to either make a proposal in relation to an MIR, either no MIR or an MIR, so as to allow timely consultation, or it can take a decision that there be no MIR. We say that these provisions make no real sense if one supposes that it still remains open to the CMA just to propose a consultation on an MIR after the 6-month mark, and a decision at some undefined point after 12 months.
I suspect Mr. Williams agrees with that in its absolute and the purest form. He simply says it's always subject to public law constraints.
Yes, but we agree everything is subject to public law constraints.
But then by definition it's not going to be rational or unreasonable.
No, but we respectfully submit that the CMA's approach deprives sections 131B, 1, 2 and 3 of any real purpose.
But that's got to be it, hasn't it?
Yes. Yeah. And that's why I emphasise the principle of effectiveness at the outset. And once one takes those core principles of statutory interpretation, puts them into the landscape of the legislation, looks at the secondary materials, we get to where the tribunal landed, we say. And again, I emphasise, because of the public interest concerns understandably raised, that there really should be no practical difficulty at all with any of this. As a matter of fact, the CMA can start getting ducks in a row before it even publishes a market study notice. I think Apple received...
The difficulty arises here because the CMA decided that it wasn't going to make a reference because it thought the legislation was imminent. And the effect of your argument, as I understand it, is that they were wrong to do that. They should, in fact, have said we're going to make a reference, notwithstanding we think the legislation is imminent, because if we don't make a reference now, or we'll give notice that that's what we're going to do, then we're going to be stuck, unable to do anything at the end of 12 months.
My lord, the difficulty arises, we say, because the CMA misunderstood what the legislation
required. The CMA gave a notice within the 6 months under section 131B3, didn't it?
It published a decision.
It published a notice of its decision not to make a reference.
Yes, my lord.
That was its interim report.
Yes, my lord, but just pausing there, if I may. This concept of interim decision-making, interim reports, features nowhere.
Well, never mind that. The fact is that it published notice of a decision not to make a reference.
It did, my lord.
What then happened is that within the 12 months, it had reached a different conclusion, but it was already on course, if you like, within section 131B, having given that notice, to produce a market study, to produce a report.
Yes, my
under
lord.
subsection 4.
Yes, my lord.
Which it did.
Yes.
And it's at that stage that they say, well, actually, now that we know that legislation isn't going to happen anytime soon, we're going to take a different course.
Yes, my lord. That's absolutely accurate as a
And
chronology.
that's something you say, well, tough. They couldn't do that.
Yes, my lord.
So how did they get out of that? How would they have got out of that conundrum? The only way they could have got out of that conundrum is by saying at the 6-month point, we're actually going to make a reference, even though we think the legislation is imminent.
But there are
Otherwise, they're stuck.
I'm sorry, Mo, yes. There are a range of ways they could get out of it, to put it in those terms. If the concern was about legislative timetable, they could have exercised their Section 7 powers and said to ministers, look, this is very important.
But we know, I say we know, I mean, we suspect that sort of thing doesn't necessarily get you anywhere.
Well, my lord,
may or may not, mayn't it? You know, and there are lots of other things going on. Which
my lord, yes, of course. There are other pressing matters which government has to consider. I fully accept that, my lord. But just to address the that can't be right, if I can put it like that. Summary. I'd like to list, if I may.
I mean, I follow the point. If there are these limits and they say they don't comply with subsection 3 and subsection 4.
My lord, yes.
I understand the point that says, well, if you were going to make a reference, you should have jolly well said so. but you didn't.
Yes,
And you're
we
out of time, and that's it. But we're in a rather unusual scenario. It might be said to not be specifically addressed by the statute at all.
So the question would be, is there any other route open to the CMA compatible with the statutory scheme which allows it to protect the important public interests at
Tribunals
stake?
struggled with that, didn't they?
They did.
Came
They
up with their various routes out. Or
yes,
whatever
and we
they
don't
described
embrace
as.
all of those routes out, my lord.
I thought you might not, Mr. Rotty.
But one we do, or two we do embrace are these. One, the fresh market study notice route. And two, if we are ex hypothesi in genuine change of circumstance territory, an argument that we were no longer looking at the same matter. Now, the first of those is potentially important and was one conceded by us at the outset to be open to the CMA as a matter of jurisdiction without any concessions made as to its application on the facts. And it's important for the MSN route, the second MSN route, to have regard to the combination of Section 5 and Section 130A. Section 5, the functions of the CMA to review information.
Yeah.
So essentially to review a changing factual landscape. And Section 130A, the obligation, not the discretion, the obligation on the CMA to publish a market study notice when it's exercising its functions under Section 5. Now, the argument that's, and the CMA, in fairness, in its defence in these proceedings, contemplated the possibility in jurisdictional terms of a second market study notice being available.
So,
But
yeah.
their position has been it'll be a terrible waste of time.
Well, I follow that, but I mean, I'm just trying to understand how this would work.
But in terms of
leaving to one side your point about whether or not in public law terms it would be permissible,
yes,
you would accept that they would have had, the jurisdiction would have been there
yes,
at the end of the 12 months to serve another
yes,
market study.
and they could, for example,
They could serve one tomorrow, I suppose.
they could. We wonder whether they might in response to the CAT's judgment, and we would have had to review it and consider whether there was a public law challenge available in relation to it.
If they'd issued one day after, 1 week, 1 month after, with no material change of circumstance, wouldn't you simply have challenged?
Yes, my lord. But we're having this debate on the hypothesis that there has been some material change of circumstance. Otherwise, were on earth shouldn't they be held to their original decision?
Yeah, I understand.
And to the point, it's all a frightful waste of time. There's nothing to stop the CMA, as the tribunal, in fairness to the tribunal, said, building upon the work of the original market study, truncating the process within the second market study, and reaching its decision points far earlier than 6 months and 12 months. Nothing says they have to wait that long. So they could
It
get
says
on with
within,
those things.
yeah.
So that's what we say, my lord, as to the primary answer to
Understood.
what it.
Thank you.
And then we have our Section 7 and our, if the matter's genuinely changed, new MIR routes as well. So going back to 131B, I think the point I wanted to really emphasise, I think I've made it already, but just to emphasise, is what's contemplated at the 6-month point. One of the scenarios, which is the one that applied here, was a decision that there should not be a market investigation reference. Not a proposal, not an interim view, not an indication. And that matters, we say, in the context of a legislation which has concepts like proposal expressly within it. Analytically, the CMA's position is really that its decision at the 6-month point was not a decision. It was an interim view, which was going to be returned to later, but not a decision. That, we say, doesn't serve anyone's interests or any identifiable statutory purpose.
Yeah.
And it's worth emphasising, again, we say in that context, that although that's the CMA's argument now, and although, as has been pointed out, it was very candidly identified as their intent in the interim report itself, if we look at the actual published decision, which is the decision that Parliament requires to be published, it says in terms, this is supplementary bundle page 140, paragraphs 6 and 7, the CMA has decided not to make a reference, and the CMA is not inviting comments on that decision. So, although everyone joins in after the interim report is published, they're certainly doing so without invitation from the CMA on this materially critical issue. So, as I say, it's page 140, and it's paragraphs 6 and 7. The CMA has decided not to make a reference under section 131. For the avoidance of doubt, the CMA is not obliged under 131B to consult interested parties before making its decision, and the CMA is not inviting comments on its decision. Well, for understandable reasons, we never challenged the earlier decision, as the tribunal called it.
Your challenge would be to uphold the decision.
Yes, but it was far too late for anyone to challenge the decision by the time we were in front of the CAT, which is one of the reasons we don't embrace that way out that the CAT contemplated. So we say section 131B 2 and 3 provide this very clear indication that there's the 6-month point, which is a significant milestone, when real time limits of consequence apply. 131B4, we've got the obligation to publish a report in relation to the matter within 12 months, requiring the report to set out findings and action. I've already made the point that below it was a centrepiece of the CMA's case that allowed somehow for the proposal to be made as an action as part of the market study, now not pursued for obvious forensic reasons. 131B5 again uses the formulation that it applies when section 131A applies, so where a notice has been published, where the CMA is proposing an MIR or proposing there shouldn't be one. And the subsection then states that in either of those circumstances, the report shall set out the decision to make an MIR, to accept undertakings or not to make an MIR. Nothing contemplating the triggering of an open-ended consultation period unconstrained by any parliamentary time limits. And then, consistent with that, and the imperative of getting on with things, section 131B6 provides that where a report contains a decision to make an MIR, the reference must be made at the same time. So everything is being focused on that 12-month point in the interests of all concerned. And as I've submitted, the whole scheme of these core provisions, therefore, is to ensure that an informed and final decision on MIR or not is taken at the 12-month point with appropriate consultation prior to that. In addition, if one wanted any doubt that a decision means a decision, we get confirmation of that later in the legislation at 174C, which I'll come to, describing publication of a notice by the CMA as a final decision on that issue. But taking things in sequence, 131C is important, and I flagged it in my summary this morning. 131C is important, we say, because it allows the Secretary of State to make an order amending the section 131B time limits to reduce the time periods it contains, not to extend them, and not contemplating that they can somehow just be sidestepped because they really only relate to some aspirational code. And that is, we say, another strong indicator from the statutory wording itself that the time limits are indeed as we contend them to be, namely hard-edged outer jurisdictional limits, which don't leave in place and alongside them a freestanding power of the kind the CMA contends for. Section 137 in the Act further underscores the importance of finality and expedition in the MIR context more broadly. It requires completion of an MIR with publication of a report within, this is page 43 of the authorities bundle, within 18 months of the reference, section 1371, with a single extension of up to 6 months permitted. And again, although those periods are capable of alteration by ministerial order, they can't be extended by that process. So those limits, those hard-edged limits on an MIR and the ministerial provision to shorten them are mirrored in the limits we're contending for. Section 138 then allows the CMA to take such remedial action as it considers reasonable and practical in the light of the MIR report, and again sets outer time limits of between 6 and 10 months for that to occur. Perhaps of passing interest, given that I mentioned it in looking at the interpretation section, section 138.3 also provides expressly in the MIR context for circumstances in which a material change of circumstance can allow an earlier decision to be revisited. Nothing equivalent to that in the provisions we're concerned with. And so the overall maximum time limits we end up with are 6 months for a proposal for an MIR, that's section 131B, 12 months for any decision that there be an MIR and the making of that MIR, that's 131B5, 24 months after that for an MIR to be completed, and then 6 to 10 months for action following an MIR. And so the market participants and the public at large are able to see, looking at this legislation, the maximum periods for which markets work can be engaged in the particular context of a published market study notice. 156 on page 60 of the bundle is also, we say, of some assistance in supporting our position on the 1314 exhaustive or not issue. You see at 1563, we have express contemplation there that the expiry of the period mentioned in 131B4 can prevent the making of a market investigation reference.
Sorry, I must be in the wrong place.
Page 6, it's section 156 on pages 60 and 61, my lord, and the provision I'm particularly focusing on is 1563 on page 61. The expiry of the period mentioned in section 131B4, jump back to that, is publish your report within 12 months and say what action you're going to take within 12 months. The expiry of that period does not prevent the making of a market investigation reference if the CMA has accepted an undertaking and so on, and certain events have followed. So it's expressly contemplating that there will be circumstances in which expiry of the periods in 131B will preclude a reference. It's just saying it won't in those circumstances.
Around your point is that where Parliament contemplates acting outside the time limits, it says so.
Yes. And it's contemplating expressly here that breach of the time limits in certain circumstances will preclude a reference.
To which the answer might be, well, that's absolutely right, but it's within the 131B regime. What does it tell you about 1311?
Well, it tells us that 131...
Well, it tells us that
where
when Parliament wants to create an exception, it says so. But it works both ways.
My lord, yes, although our regime, if you like, as I would have it, embraces both section 1311 and 131B. (169), my lord, is the next provision I wanted to emphasise, and it's we say of particular importance because it illustrates very clearly the two different and mutually exclusive tracks which apply. One where a market study notice has been published, and one where there is no market study notice. it concerns the duty of the CMA to consult interested persons in non-market study cases. And we see that because 1691 and 2, by 1691 and 2, the CMA is required, so far as practical, to consult any interested person about a relevant decision. And then by 1696 on page 64, relevant decision means any decision by the CMA to make a reference under section 131 in a case where the CMA has not published a market study notice in relation to the matter concerned. Now we say it's really impossible for the CMA's case to be reconciled with section 169 on any view, given the common ground between us as to the ultimate proposal for an MIR and the making of the MIR. This was a case in which the CMA had published a market study notice. And it's therefore not within the 169 duty of consultation and the 169 regime, but it is very much within the 131A and B regime. Now finally, before going to the secondary materials, which I've trailed repeatedly and hope live up to their billing, but so far as the legislation is concerned, as I've indicated, we say section 174 is important. This is page 70 of the authorities bundle. By virtue of subsections 1 and 2 to 5 of section 174, the CMA obtains the far-reaching investigative powers the moment it publishes a market study notice, and as I've already submitted, without any evidential threshold being crossed. And notwithstanding the fact that regulators frequently enjoy them, we do respectfully embrace an adjective of intrusive. And we emphasize that in the context of no evidential threshold being crossed. You can require anyone to attend to give evidence, you can require production of documents, you can require production of commercially sensitive information, and you can impose penalties for non-compliance. And criminal offences are committed by any frustration. There's very good reason, we say, against that background, why the publication of a market study notice makes a difference, and why a proper conception, a properly broad and multifaceted appreciation of the public interest shows that hard-edged jurisdictional time limits are triggered. And section 174C3, I then also wanted to mention, I referred to it earlier, you have it on pages 82 and 83, and this provision complements section 174B by defining a specified period during which a penalty for non-compliance with section 174 powers can be imposed by reference to the day when the CMA finally decides whether to make a reference. And 174C3 defines day when the CMA finally decides not to make a reference as including, for our purposes, 3C, when the CMA publishes notice that it has otherwise decided not to make such a reference. So that reinforces the submission I made earlier, which we say flows from the language used, that decision tends to mean decision, not proposal, not indicative view. So that's the legislation itself, and we say it strongly supports, once one looks at the whole scheme, the tribunal's conclusion that if you were going to propose a market investigation reference, you had to do so within 6 months. If you were going to make a market investigation reference, you had to do so at the 12-month point. And that conclusion is then, we say, strongly supported by the secondary materials, which the tribunal also has in the authorities bundle at primary secondary materials at page 115, the explanatory notes. And the particular passages we rely upon are on page 116, first of all, with the general introduction to the reforms to Part 4, which is what we've been looking at, of course, relating to the CMA, and an emphasis in the first sentence on the statutory purpose, as I sought to summarise it when I stood up this morning, namely the promotion of speed, quality and robustness of decision-making. And then going to the more detailed passages in the explanatory notes, at page 120, paragraph 280, we have the rationale for the introduction of investigative powers throughout the markets process as a corollary of the statutory time limits, as we've seen in terms of the powers reflected in section 174 of the Act. So the core purpose, at least in the view of the author of these explanatory notes, is to promote expedition, and that is then served by the granting of new powers to ensure sufficient information is available to the decision maker. Paragraph 284 on the next page, emphasising that the powers are not available before publication of a market study notice. Paragraph 297 on page 122, the next page, to similar effect and summarising the position in the matter that Apple contends for in the last 3 lines of that paragraph. Taken together, these sections limit the time period during which parties may be subject to markets work. Markets work, not a market study, not we're creating a code just for market study, but markets work that give the CMA a strengthened ability to gather information in order that the timescales can be met. And that illustrates the point about balance that I also started with. The balance between ensuring the CMA has appropriate powers to investigate and so to adhere to statutory time limits, but the balance also recognising, as the tribunal noted in this judgment, repeating findings in earlier judgments, that markets work is intense and places very significant burdens on those the subject of it. Now that objective of limiting the time period during which a party may be subject to markets work is, we say, an objective which is simply not met by the CMA's interpretation of the legislation. Nor, we would say, is the objective of speed of decision-making met. Nor is the wider public interest of expedition served. Still in the explanatory notes, paragraph 298 on page 122, again emphasises the fact that it's the market study notice which triggers the start of a statutory time period for the completion of the market study, and 300 through to 303 all in similar vein. None of those paragraphs contemplate that proposals for or representations in favour of an MIR in relation to the subject of a market study notice can be made outside the timeframes Parliament has laid down. On the contrary, as stated in paragraph 301, the purpose is to ensure that representations are to be made in good time and to enable the CMA to consider them as part of the market study, not, as the CMA apparently suggests in this case, after, or we would say, artificially disconnected from the market study. None of these passages contemplate that a decision not to make an MIR at the 6-month point is other than final. None of them contemplate that the 12-month period for completion of the market study report can properly end with commencement of a yet further undefined period of consultation. And the notes state, we say, accurately and unequivocally at 303, in cases where a market investigation reference is to be made, this should be made at the same time as the market study report is published, within the 12-month deadline. And nothing surprising about that, we say, once one has in mind the various legislative provisions, but nothing remotely supportive of the CMA's case on this appeal. So to summarise and draw it together, I hope, 4 points emerge, and apologies, this will involve a degree of repetition, but I'll go very quickly, but just to draw it together. The introduction of the time limits was to be considered alongside the expansion of investigative powers to enable the CMA to obtain whatever it needed at an early stage in the market study process and before any view had been reached on appropriateness of an MIR. Secondly, the limits were just that. Limits, not targets. Limits, not periods capable of extension. Not limits, not periods part of some unenforceable code. Thirdly, the overarching intention was to ensure that any representations were made in good time to allow the CMA to consider them within that 12-month time frame. And fourthly, there was indeed an outside limit for making an MIR of 12 months, where the MIR was in relation to the subject matter of the market study notice. That's the statutory test. The question is whether the market investigation reference proposed in this case and ultimately decided upon was in relation to the subject matter of the market study notice. If it was, the time limits applied and were breached. The statutory test is not, did you make this market investigation reference proposal later than the end of the 12-month period for the market study, for example. As, perhaps to put it less eloquently, we say the CMA's case boils down to. Now that is what I perhaps rather inelegantly describe as the primary source of secondary materials. The secondary source of secondary materials is the government's own consultation paper preceding the introduction of the time limits. They too, we say, support Apple's case. They're not in the authorities bundle, actually, they're in the supplementary bundle. I'd like to go to those briefly. They're in tab 1, and it's page 3 is the first passage that I wanted to draw to the court's attention. At the foot of the page, on page 3, the passage there emphasises the support for time limits at all stages of a market's case.
I'm so sorry, I'm just catching up. This is the consultation paper.
March 2012 consultation paper,
Yeah.
preceding the introduction of section 131A and
Tab
B.
1.
It's tab 1, and it's,
To be precise, it's the government response to
I'm
the
sorry.
consultation.
you're
Yeah.
absolutely right.
Oh yes, absolutely. We've seen this actually in some collective action cases. I mean, one of the problems with this is that this is all, pre-legislation. It's the views of the government at the time prior to the actual decision as to what they're going to place into legislation.
That's absolutely
It's
right.
reasonably distant from, but I mean, we have cited this before in some of the collective action cases.
Yes,
Yeah.
I called it the secondary
I'm not sure how
materials. and
helpful it is, really.
But
It's all of in the same direction as the
Yeah.
explanatory notes.
sorry,
All
just
consistent.
for my note, I mean, I haven't, just give me the paragraph numbers again.
Can I just give you the references, Mo? Yes, page 6,
Page 6.
foot of the page.
Yep.
Last paragraph there.
So I think that's bundled page 3, is it not?
Yes, I'm so sorry. Bundle page 3. I'm sorry. Yes.
Yeah, page 3.
Okay. That's recording what the majority of respondents
Yes.
to the consultation paper.
Yes.
Yeah.
And it's all of a piece with the idea that all time limits are needed to ensure greater certainty to reduce the burden on business. The next page, page 4 of the bundle, the government has therefore decided to require the CMA to consult on making a market investigation reference within 6 months of launching a market study where such an outcome is being considered, and conclude all studies within 12 months. So again, we say, supporting our outer limit, supporting the idea that if to be any question of a proposal for an MIR, it has to come within the first 6 months. Page 7 of the bundle, paragraph 420, first bullet point, statutory time limits. Government has decided, to meet my Lord Justice Green's point, has decided statutory time limits and information gathering powers for market studies that will require the CMA to consult on making an MIR within 6 months of launching a market study where such an outcome is envisaged. 421 on the next page, the CMA will be required to consult on a decision to make an MIR within 6 months. 424 and 425 on the same page, again we say emphasising that the time limits were accompanied by enhanced investigative powers to enable the CMA to meet the necessary time limits. So all of a piece with the explanatory notes, or we say favouring the characterisation of these limits as limits. Nothing in the CMA's own published guidance to actually contradict any of that. Now, that's not strictly admissible or relevant as statutory interpretation material, but it perhaps shows that there's a danger of exaggerating public interest concerns. Now, my Lord, that is what I wanted to say about the secondary materials. That was the second of my 4 reasons why the tribunal was right to conclude that it was. The third of my 4 reasons was that the effect of the CMA's interpretation would be to largely deprive the time limits of any effect, to render the decision taken in December 21 not to make a reference, nothing more than a provisional view, and to frustrate the statutory purposes I've just referred to. Now, I've flagged that point a number of times already. What I'd like to do, if I may, is just show the court, what the tribunal said about those issues. And it's in the core bundle, the judgment, tab 4, and a number of passages I wanted to emphasise in that regard. First of all, paragraph 31, the tribunal citing its earlier Airwaves decision, drawing attention to the fact that market investigations were intended to be short and intense, as reflected in the statute, with the reporting timeline we say it established. Paragraph 33, the tribunal summarising the CMA's case as being that the original decision, what it called the earlier decision not to make an MIR, in no way circumscribed the CMA in making a self-standing reference. 34.1 on page 68 of the bundle, the tribunal pointing out that the effect of that will be to render the earlier decision not to make a reference an essentially pointless intermediate step, which the CMA was required to take for no particular purpose. Put another way, as I've sought to submit already, far from being a decision deciding anything of significance, creating any certainty or finality for anyone, it will be a potentially misleading non-decision, generating an unfounded sense of finality for undertakings concerned. Now, except in the context of this case, no one would have been led astray by that because of the accompanying interim report published at the same time. But analytically, if that's what all that a decision amounts to at the 6-month point, it, in other contexts, is very much capable of misleading. And certainly if one was looking simply at the published decision, one would be at serious risk of being misled. 37, in the judgment, the tribunal emphasising that, again, the demanding, burdensome nature of demands made under market studies, as explaining why the CMA's powers in this regard, as it put it, should be circumscribed by primary legislation. And 48 to 50, the tribunal explaining why tying any MIR to the market study it arose out of and adhering to the time limits that entailed made sense both from the perspective of market participants and the CMA.
do you accept that amongst this portfolio of objectives is that which the CAT refers to in the first sentence of 37? The statutory duty to promote competition both within and outside the United Kingdom for the benefit of consumers. You've identified things which I don't suppose anybody's going to object to. They're important. The desire for speed, timeliness, finality, they're all very important. But are you saying they're the only?
No, my lord, I entirely embrace that first sentence, and that interest is served by what the explanatory notes describe as speedy, robust decision-making. And that interest is entirely served by a
That's not the end result of your client's submission in this case.
Because if you're right that there has to be leaving aside the public law implications, you accepted an answer to me a little while ago that they could have served another market study notice and then engaged in, and they could have truncated the process.
Yes.
I follow that point, but truncation of the process is one thing, but you're still going to lead. What you're going to have is a longer, more expensive process than you would otherwise have if the CMA are right. Which doesn't seem to chime all that well with the interests of the consumers who may be affected by the allegedly anti-competitive conduct.
I mean, two points, my lord, in response to that. Firstly, it wouldn't, in every case, necessarily be longer, because use could be made of the original market study. The second one could be truncated. Secondly, and to my lord, but my lord's point and to my Lord Justice Green's point, as I've sought to stress on a number of occasions, the importance of the 12-month time limit and the 6-month time limit isn't just to give certainty to the market participants. It's to ensure the CMA makes speedy decisions in the interests of the public and gets on with things. Now, what happened in this case is we ended up with a proposal for an MIR that should, if, as we would have it, Parliament's intent was being properly respected, had been proposed in December 2021, within 6 months. It was actually proposed 100% in terms of time later than that, in June 2022. And if Parliament's intent had been honoured, as we would contend it to be, a market investigation reference should have been made in June 2022, within 12 months, rather than in December 2022, or November, 2022, as occurred. So these weren't marginal misses of time limits proposed by Parliament. And those time limits, we say, very much serve the first sentence of paragraph 37, the fact that in this case, because as we contend the position to be, the CMA misunderstood and downgraded those statutory time limits, a problem has arisen, doesn't undermine analytically the correct interpretation of the statute. And that leaves only, my lords, my fourth answer to ground one of the appeal, which presentationally I contemplated putting first at one level, because it's to meet what the CMA describes as its central case and what the CMA describes as the central error of the tribunal, set out in the skeleton of paragraph 51, or the CMA skeleton of paragraph 51. And the CMA's case is that none of this mattered, and the tribunal simply went astray because it failed to appreciate that what was under scrutiny here was something taking place outside the market study context. Look, we made our proposal at the end of the market study. Look, we made our decision 5 months after the conclusion of the market study. Therefore, all of your submissions about time limits applying in a market study context are jolly interesting but completely irrelevant. Well, that, we say, is entirely artificial as a matter of fact, once one appreciates that everything which led to the proposal for an MIR in June 2022 flowed from the market study. And very much the bulk of the ultimate material justifying the ultimate decision that there be a market investigation reference lay in the market study too. It's entirely artificial, we say, to say that this reference was proposed or made outside the market study context. But more fundamentally, the problem with that argument, as I said earlier, is that it simply misstates the statutory limit. The statutory test in relation to limits. If I'm right so far, that section 131A and B do indeed impose limits on the CMA's power to make a reference, then they impose limits when the proposed reference is, to use the wording in the statute, in relation to the matter specified in the notice. And it's common ground that the reference proposed here and the reference made here was in relation to the matter, the subject of the notice. So, far from being a central error on the part of the tribunal, we respectfully submit that there's a central error in the CMA's case. And these are the points we make at paragraphs 36 to 40 of our skeleton. So for all those reasons, we say, my lord, ground one fails. I'd just like, if I may, and if the court could turn it up, to respond to some of the sort of broader policy objections to our case, which the CMA sets out in its skeleton argument and which were addressed by Mr. Williams this morning, so that I make our submissions on them clear. They begin at paragraph 64 of the CMA's skeleton on page 38 of the core bundle. At 64, it said that the tribunal's approach was vague and convoluted, or gave rise to a scenario which was vague and convoluted. We respectfully submit there's nothing vague or convoluted about determining whether the matter specified in a market study notice has changed to a significant extent over time, that it is no longer properly characterised as the same matter, and so could be the subject of a fresh MIR. The language in relation to the matter specified is the language Parliament has used. Now, on the facts before this court, it's entirely clear that the MIR and the MSN, as I've said, were indeed in relation to the same subject matter, so the point just doesn't arise here. But in any event, in circumstances where, different circumstances, where the CMA did consider that, for example, a fluxion of time meant that you were no longer looking at the same matter, it could make that case. As to 65, we say, for all the reasons I've been giving, seeking to explain, that the tribunal's interpretation is indeed entirely consistent with the statutory scheme, far from the contrary. As to 66, and the assertion that it's right in principle that the CMA should be able to propose, make, consult, and go on to make a reference in response to new circumstances and evidence that arise during the second half of our market study. Well, we say that just runs counter to the statutory scheme unless you are in territory. To go back to the points that I was seeking to address earlier, unless you were in territory where it could genuinely be said that the change of circumstances meant that this was a different matter, or where you chose to address those changed circumstances through a new market study notice. 67, and the suggestion that a protective proposal at the 6-month point would waste public resources and create undue uncertainty. That, we say, is not the case. On the contrary, an approach which allows the CMA to describe something as a decision, allows the CMA to state, we are not inviting comments on this decision, but then to reverse it is much more liable to create uncertainty.
Yeah.
As to 68 and the suggestion that the judgment somehow incentivises the CMA not to issue a market study notice because it may not want to trigger the application of the time constraints. Well, first of all, that ignores the benefits that the CMA obtains on day one by issue of the market study notice, namely the receipt of intrusive powers. Secondly, if the market is genuinely subject to rapid change, which is the hypothesis addressed in this paragraph, then the CMA one would have thought, have had every greater incentive to move quickly and comply with the time limits, and would be very unlikely to have difficulty in doing so. Thirdly, there's a great risk, we say, of overstating any difficulty the CMA faces in complying with the time limits. I've mentioned the powers it gets. I've mentioned the very low threshold it has to clear to make a market investigation reference. By definition, the threshold to clear in proposing a market investigation reference is even lower. But as importantly, perhaps, the CMA can also get on with preparatory work before it even publishes a market study notice. Now, in this case, Apple received a 77-page request for further information on day one of the market study process, simultaneous with the publication of the notice. So there's really no difficulty, we say, in the CMA complying with the time limits. And fourthly on this, about the risk of incentivizing the CMA not to issue a market study notice, that submission ignores the fact that section 130A of the Act, as I've shown the court, shows that it's a duty, not a discretion. It's a duty to issue a market study notice when you're embarking on the information review process. So, my lords, that is all I wanted to say on ground one, unless I can attempt to assist further on it. And ground two, I can be as short as I was earlier, I would respectfully submit. If we're right on ground one, ground two falls away. If we're wrong on ground one, ground two is not needed.
Yeah.
And the issue, as I emphasised at the outset before the tribunal, was vires and vires alone. And we rest our case on that. Unless there's anything else I can attempt to assist with. That's
Thank you very much indeed.
No, thank you very much, Mr. Roddy. Yes.
My lords, I'm going to start with an overarching point, which I think is in some ways my response to most of what Mr. Otti has said, because you have my submissions on the interpretive arguments, and then I'll make a few more specific points. Mr. Otti has placed a significant weight, understandably, on the imperatives for, on the one hand, speedy decision making, and on the other hand, the need for respect for deadlines. And of course, as a general matter, no one disagrees with those objectives as desirable objectives in public interest decision making. Really, the question is whether this is a case in which the ordinary model that is provided for in the sections of the Enterprise Act that we've been looking at, sections 1 through 1A and B, has to some extent broken down because of supervening circumstances. Does the statute prevent the CMA from acting as it did in these circumstances? And you have all the arguments about that. But of course, most cases won't be like this. Most cases will involve the CMA following the statutory timetable, taking the steps that are required, and the code operating as it's intended to provide an orderly process with deadlines for decision making. The court's seen that some really quite particular considerations arose in this case, and that's what led to, in my submission, is likely to be the unusual course of the 12-month point not marking the end of the process in real terms, because the CMA took the view that there was cause for further consultation. So the overarching point I make is that nothing in our submission means that decisions aren't decisions. Nothing in our submission means that deadlines aren't deadlines. Really, the question we're dealing with here is one of statutory construction, and whether all the points that Mr. Otti is making add up to a constraint on vires, which bites in a case like this. So then, just to pick up a few of his points, I mean, of course, I think the court has my case from the submissions I made earlier. A key point that Mr. Otti has emphasised through his submissions is the importance of time limits and the importance of the constraints that were introduced through sections 1 through 1A and B. And it's really important to bear in mind that until sections 1 through 1A and B, the duration of a market study was unbounded. And so the CMA could start a market study in its parlance as it then used that term, was different from the statutory scheme we now have, and the work could continue indefinitely. And what Parliament has clearly determined is that stage of the investigative process is time limited, and that as part of the package of measures that have been introduced to put in place those time limits, the CMA has been given information gathering powers. And so taken in the round, clearly the introduction of those reforms has introduced effective pointed time limits which constrain the CMA's powers of action and which constrain the period during which the mandatory powers can be exercised. Likewise, the intermediate steps in the process, the requirements for notice to be given by a particular point in time, for consultation to be taken by a particular point in time, those are all effective milestones which have to be complied with in any process. And really what this comes to is whether the requirement that Mr. Ottie's described for the CMA to make a decision at the 6-month point, if it's not minded to make a reference, whether that is a once and for all decision or whether it can be revisited in appropriate circumstances. And in my submission, there is no inconsistency between the point we make on the one hand, that is clearly a legal decision taken in accordance with the statutory framework and in accordance with the legal requirements, but on the other hand, a decision which can be revisited if there is appropriate reason to do so. There's no incompatibility between those two points. So Mr. Ottie is right to say that under this statutory scheme, there's a fork in the road. The only question is whether that fork in the road is once and for all. Second point, when the CMA makes a decision at 6 months and receives late representations after the statutory deadline, what can it do with those representations? Is it entitled to take them into account? In my submission, that the court doesn't need to grapple with that question in its purest form in this case, because as the court's seen, this case wasn't really just about the receipt of late representations, that there was the issue of the supervening change of circumstance in relation to the legislation. So that issue, which we can see raises distinct issues, is not one which arises on the facts of this case. Third point, 1314 is not exhaustive. 2 points in response to that. In my submission, the point Mr. Ottie made with reference to 169 is not a powerful point in this context. 169 is not a section which purports to go to the CMA's vires. Clearly it's an important aspect of the statutory scheme, but it doesn't operate in the same way as 1314. And the point we make about...
I'm sorry, can I be clear? I appreciate you have a point about 169, but dealing with the submission in its own terms, do you submit that section 131 subsection 4 is exhaustive?
Well, I, speaking for myself, haven't identified another limit on the CMA's vires properly so defined within the statutory scheme, other than those in section 1314. I don't want to put that too high.
But by vires you mean the trigger in 1311, the may. It's
To
what
the
triggers
power.
that's the power.
Yeah, well, sorry, my lord's quite right. The argument works in 2 stages, doesn't it? Does this section 1311 provides the threshold test, and section 1314 creates a carve out from that virus. So
The virus is the word may, it's a power.
yes,
You can exercise the power when there's reasonable grounds.
yes,
Yeah.
There is no power if you're in 1314.
that's right.
Yeah.
No reference shall be made.
That's right. Now I haven't.
So it's not a matter of discretion, it's an absolute provision, there's no
Yes.
virus.
And speaking for myself, I don't think I've identified another provision of this in the legislative scheme which takes away that prima facie virus under section 131. Section 169 is clearly an important application, but it's not one which operates in the same way as section 1314, whereas Mr. Ottie's submission does work in the same way on his case.
So it
That's
does
section
boil down to
1314.
what did Parliament intend
Yes,
in
that's
the
right.
structure between 1311 and 4,
Yes,
and then 131A and B, possibly 169.
yes, and I don't need to submit that section 1314 is or isn't exhaustive. The point we make is that in construing the scheme and in construing the language that's been used by Parliament and seeking to identify Parliament's intent, the presence of section 1314 is a powerful indicator in my submission that the provisions Mr. Watties relies on do not go to VIROs, because there are clear provisions in the Act which operate in the way that he says sections 131A and 131B operate, but they just aren't part of those provisions. So it's a point which really goes to natural construction.
And actually, section 1311 itself says the CMA may, subject to subsection 4, make a reference. On Mr. Ottie's case, one would expect to say subject to subsection 4 and sections 131A and 131B.
I probably don't need to spend time on the question of whether the time limits go to VIROs or process. That was really what I spent most of my submissions dealing with.
Yeah.
We made 2 points. First, natural interpretation. Secondly, practical consequences. And I won't try the court's patience by going back over that territory.
Well, if you'll forgive me, I have one question
Of course.
in that area, which is section 131A, subsection 1. It might be helpful to have it in front of us.
Yes.
Authorities bundle tab 1, 19.
Yes.
So 131A, subsection 1. Mr. Ottie's submission is that on the literal wording of that subsection applies on the facts of the present case. So, just for the sake of clarity, do you accept that? If you don't accept it, can you just clarify for us why not?
Well, we accept that if one reads those words in what we would characterise as an overly literal and context-free way, that they can be applied to the facts of this case in the way that the tribunal did. But that in our submission is not the question. The question is, how should the words be construed as part of the statutory scheme in order to give effect to the intentions of Parliament? And we say that the flaw in the tribunal's interpretation is that it did read those words in a completely context-free way, and it read them as saying, well, because this box is ticked and that box is ticked.
So can I be clear? You accept that on a literal interpretation of the language of the subsection it applies, but you submit that the error the tribunal made was not to interpret those words purposefully.
Well, we say that on a
context.
purely literal interpretation they can be applied to the facts, but we also say that on a,
Let's just be quite clear about this. Your position as set out in the new decision is not that they fall within these facts. You say that it's context, but the case that you're defending is not a case where you've published a market study
No.
and you're proposing to make a reference.
No.
Because you've started with a new 131 under consultation. You accept that it's part of the historical context.
yes.
And the question is, what is this referring to? This section applies to a case where you published an MSN and you're proposing to make a reference. Well, that's a reference to what happened in the past, not what's happening today.
My lord's quite.
That's how I understood your case.
Yeah.
Yeah, no, my lord's quite right. I mean, perhaps I was giving an overly literal response to my lord's question. We say that the natural, literal reading of the words is that this is dealing with a sequential process in which the CMA has issued a notice and it's proposing to make a reference in a market study which is being carried out pursuant to that notice. And we say that is also a literal construction of the words. And we say that's the correct construction of the language. What I said in response to Lord Justice Arnold is that we can see how the tribunal has fitted the words around the facts, but we say that first of all that's not the natural way to read the language, whether one describes that as literal or natural.
Can I just be precise as to where you say the error in interpretation lies? So does it come down to the meaning of the words in relation to the matter specified in the notice, because it's a different matter?
No, we're not saying it's a different matter, because the subject matter of the market investigation reference in this case was effectively a subset of the broader subject matter of the MSN, so we accept that. what we say is that this was not a case in which the CMA had published a market study notice and was proposing to make a reference under 131 in relation to it, because the CMA was acting under 131 on a freestanding basis. And we say that's a permissible, literal, natural reading of the language. And what we then say is if one brings purposive and contextual considerations into the equation, then it becomes perfectly clear that that's the correct way to read the section. So I hope that's but the way Lord Justice Green put it to me is correct. That's our
It's the
position.
first line. This section applies to a case where the CMA has published a market study. You say, well, we did in the previous decision-making
Yes.
process, but we haven't in this.
Yes, exactly,
That's-
exactly, Mike.
You know, so I mean that's your analysis of what's happened chronologically.
Yes.
If you look at this, the little a, then it is true if you take that in isolation. The CMA is proposing to make a reference under 131 in relation to the matter specified in the notice.
Yeah. That's exactly.
And the question is whether you're right to treat it as two decisions or really, as the CAT thought, a continuation of the first.
But yes, we do say that this is not a case where the CMA has published a market study notice other than historically, and we say that's not the relevant way. That's not the appropriate way to construe the section. So I mean, I think that comes down to saying that as a yes/no answer, no, we don't accept that the literal construction of the section applies. I was simply saying one can see the way in which the tribunal has fitted the language to the fact. We don't agree that's the literal construction.
I got that, and just be clear from your paragraph 70 and 71, where you accept that time limits in an earlier decision-making process may be relevant to the exercise of power. And if you ignored them through your negligence or carelessness, you could find yourself subject properly to a public law challenge.
Yes.
But you're dealing with two processes, whereby what happened in the first remains relevant to the exercise of the power in the second.
Yes. Yeah, that's exactly right. And in fact, for the court's reference in relation to Lord Justice Arnold's question, in terms of the argument before the tribunal, the court will see the CMA's defence at supplementary bundle tab 12.282, paragraphs 57 and following. That's where we set out essentially this argument that section 131 doesn't apply on the facts of this case. Turning to the way out, I don't need to spend much time on this because I dealt with it in my submissions. I mean, Mr. Rotti's submissions on the way out of the current predicament came down to 2 points. One is that on some facts there may be a change in the matter, but that this isn't a case where there was a change in the matter. The relevant changes of circumstance were different sorts of change of circumstance. So that's not a solution on the facts of this case. And so what he's left with is second MSN route. That's what he says is the solution. And for all the reasons I developed in my submissions, that is not, in my respectful submission, a cogent answer. It's not a cogent way for the statutory scheme to work. It's not cogent for the CMA to be forced down that route again before it can exercise its power. And it introduces the sorts of inconsistencies which I identified in my submissions. So Mr. Rotti's concession that there is another route by which the CMA can go about this, it's very double-edged for him in my respectful submission. And what it really demonstrates is that these time limits are not hard-edged time limits, and it's really just a question of how the CMA gets to what must be the correct end point.
You'll correct me if I'm wrong, but I noted down it was that the second MSN based upon information which could not have been made earlier, otherwise it would be irrelevant. So he's not going to let you off the hook simply because you try and cure your previous deficiency and plug it with some new evidence that could have been, but was not, collected earlier. Is that right?
Yes, well, I certainly wasn't conceding that if we get that in
No,
post
I
tomorrow,
understood
we
you
won't
not
back it.
conceding the point.
I'm sorry, my lord.
I understood you not to be conceding, as
No.
it were, the public law issue.
I was simply
Simply
acknowledging
saying this is what you
jurisdictionally
can
that
do,
there
it's a matter
was.
of mechanics.
Yes, Michael, and the
Yeah.
point being that there's no prohibition in the statutory regime on a second market study notice and no regulation of that, whereas there is on an MIR in the context of a published market study notice.
And what we say in response to that is that really once Mr. Watty gets to that point in his submissions, his argument from mischief really collapses at that point, because it's really just a question of how the CMA gets to the end point rather than whether it can get there. And in my respectful submission, that really does seriously undermine really a large part of what he submitted to the court today about the importance of
Both
time.
of the ways out would lead to a dead end, because you didn't get information first time round, and people could have. And secondly, there's no change of circumstance which would take you out of dealing with the same matters. So you'd still be called by the in relation to.
Yeah, and the court will understand that faced with the tribunal's judgment, the prospect of issuing another MSN and then entering into another frontier of litigation with Apple about that wasn't an appealing prospect. So here we are. I think the final point I need to cover is Mr. Watty's submission based on the secondary materials, and this point does rather dominate his skeleton argument, which sets out significant extracts from the explanatory notes and the CMA's guidance. And really this just goes back to my first point, which is that all of that commentary is consistent with our submission, that the timetable laid down in statute is the timetable for a market study, and in most cases that will be the timetable. What one doesn't get from any of that material is that the deadlines are once and for all in a case like the present. So they just don't address the issue, which has come into focus in this case, and the present case may raise difficulties that simply weren't anticipated by the authors of that guidance. The high watermark, I think, of Mr. Watty's argument based on the guidance is 297 of paragraph 297 of the explanatory note, which it might be worth going back to at Authorities Bundle 122. And this is the reference to overall limits on markets work, which is a vague expression, if I may say so, but it does seem to be directed at the combined effect of a market study and a market investigation. Now, all this is saying, in my respectful submission, is that what is now the case under the legislation as it's been reformed is that there is a time limit on market studies, which can be which works in tandem with the time limits which have always applied to market investigations. Although I think that they may have been shortened by this legislation from 2 years to 18 months. And so it is true to say that in the ordinary case where a market study is conducted and it leads on to a market investigation, there is now an overall time limit on that process, where previously there wasn't one. But in my respectful submission, this is not purporting to deal with the much more refined question that the court is grappling with, which is whether the time limits in sections 131A and 1B ought to be construed as limits on the CMA's virus. This point really goes nowhere near that question. Although Mr. Watty did really put a lot of weight on the explanatory materials, in my respectful submission, they really just don't grapple with the more difficult question that the court's now dealing with, and they don't assist the court. They're consistent with both parties' cases. So I think that covers everything, my lord, unless there's anything else I can assist you with.
Thank you very much.
Thank you.
My lords, there is one other thing that I should say. The court may well have this in mind, in which case please stop me, but at tab 7 of the core bundle, the court has the order made by Lord Justice Green when granting permission, and the court may be aware that this is a case where there is effectively interim relief in place, because orders have been made.
I extended yes, that's right.
That's right. So unlike some cases, this is a case where there is a case waiting behind the court's judgment, and I've simply asked to draw that to the court's attention before we conclude today.
So you wanted out with less than a year?
Yes.
Said less than. Is the court appeal? We understand.
I'm
Yes.
grateful for that.
On that note, thank you both very well. Thank you all very much for your extremely interesting and helpful submissions. We are inevitably going to reserve our judgment, so see 5 to 4 on a Monday, Tuesday, sorry. And we will get you a judgment in draft as soon as we possibly can in the light of what you've just told us, which I think we were conscious of anyway. When you get the drafts, please, it's just for typographical corrections, not for inviting the court to revisit its decision. Please pay close attention to the terms of the embargo at the top of the draft and ensure that the draft is only seen by those people who are involved in the process of looking at whether the typos or not, and obviously considering things like what might happen in the future. But it mustn't go beyond the limits of what's set out there. That's a point that Master of the Rolls is very keen that we emphasise to all counsel. So if I'm teaching you to suck eggs, I